film partner the matter of Maranello Rosso Ltd and Lohomij BV others.
Good morning.
Good morning, my lady. I was turning next to deal with the implied question. I apologise for my voice. I'm hoping that the court can hear me. So I shall do my best.
Well, I'm sorry for you, and I hope that it's nothing more than a frog in the throat, and that we won't all have COVID tomorrow.
No. Tests have been taken and have been negative. So I'm dealing with the implied term question, which MRL sought to add by amendment in the briefest of terms to paragraph 67A of the particulars of claim. And if I may just show the court that, please. It's in the core bundle, tab 16, at page 386.
I'm sorry, I just have to get my bundles under control. I'll be a moment. Yes.
My lady sees there, 67A, it was an implied term of the amended facility agreement that Lohomij would not prevent and or interfere with any proposed sale of the cars and or would act in accordance with an implied duty of good faith. And then there's a reference to a alternative duty at common law, but I understand that's not pursued. And then breach of this obligation is pleaded in draft at page 404 of the same document. Paragraph 134. Lohomij has acted in breach of clause 9 and or the implied duty not to prevent and or interfere with any prospective sale, etc. And as the court sees over the page, this actually only applies to sale 1. There's no factual matrix pleaded in support of the implied term, so the existence or otherwise of the term is a question of law. And the judge rightly grasped the nettle and concluded there was no such implied term. I don't understand MRL to criticise the judge for deciding the point, but MRL says the decision was wrong. As it's put in paragraph 90 of my learned friend's skeleton, the answer is obvious, but yet the judge reached the opposite conclusion. We deal with this in paragraphs 84 to 87 of our skeleton, and of course I adopt our skeleton in respect of all our arguments, even though I haven't specifically mentioned it. The law on implied terms was authoritatively restated in Marks and Spencer's, and since there is a difference between the parties as to the correct application of the relevant principles, may I just very briefly take the court to that? It's in Authorities Bundle 2 at tab 14. And at page 752 of the report, in the speech of Lord Neuberger, paragraph 14 is under the heading Implied Terms in Contract. Paragraph 15, Lord Neuberger observes, by reference to an earlier statement of Baroness Hale, that there were two types of contractual implied terms. The first implied into a particular contract, in light of the express terms, commercial common sense, and the facts known to both parties at the time the contract was made. And the second is the type implied by law, sometimes by statute, sometimes through common law, in respect of certain classes of relationship. I think the way MRL puts their case is they're trying to ride either or both of those horses. Paragraphs 16 to 20 then is a recitation of decisions of various judges, often at the highest level, in respect of the applicable principles. I would just wish to draw the court's attention to two particular paragraphs. First, at paragraph 18, there's the well-known set of conditions described by Lord Simon in the BP refinery case. For a term to be implied, the following conditions, which may overlap, must be satisfied. 1, it must be reasonable and equitable. 2, it must be necessary to give business efficacy to the contract, so that no term will be implied if the contract is effective without it. 3, it must be so obvious that it goes without saying. 4, it must be capable of clear expression. 5, it must not contradict any express term of the contract. And then paragraph 19, there's an extract from what Lord Bingham, Master of the Rolls, said in the Phillips and British Sky Broadcasting case. Let us see on that page. The question of whether a term should be implied, and if so what, almost inevitably rises after a crisis has been reached in the performance of the contract. So the court comes to the task of implication with the benefit of hindsight, and it is tempting for the court then to fashion a term which will reflect the merits of the situation as they then appear. Tempting, but wrong. It is not enough to show that had the parties foreseen the eventuality, which in fact occurred, they would have wished to make provision for it, unless it can also be shown either that there was only one contractual solution, or that one of several possible solutions would without doubt have been preferred. And as Lord Neuberger explains at 21, in his judgment, the judicial observations so far considered represent a clear, consistent and principled approach, to which he adds 6 comments. I think of those, the one I would simply draw attention to is at H, or just above H. Secondly, a term should not be implied into a detailed commercial contract merely because it appears fair, or merely because one considers that the parties would have agreed it if it had been suggested to them. Those are necessary but not sufficient grounds for including a term. And we say that what's happened in this case is exactly really what was being warned against by Lord Bingham in the passage cited. MRL argued for the implication of a term with the benefit of hindsight because, for Sale 1, they never got to the stage of seeking consent under Section 9 of the amended facility agreement. So, they say, had the parties foreseen that which they allege, namely that Mr. Lown and Mr. Schlumpf sabotaged a potential sale, then surely the parties would have wished to make provision for it. And as Lord Bingham put it, that may be a tempting approach, but it's the wrong one. And of course it's telling that this supposedly obvious and necessary clause did not even occur to MRL until after a defence was put in, pointing out that Sale 1 did not engage Clause 9 of the amended, Section 9 of the amended facility agreement. That brings me then to the arguments advanced in MRL's skeleton. It's at paragraphs 89 to 93. Paragraph 89 begins with the argument. It's at page 59 of the core bundle. If the court has skeletons in the core bundle. Paragraph 89 begins by Clause 9 of the amended facility agreement. Lohomij was in effect prohibited from unreasonably withholding its consent to the disposition of any of the cars. It may not matter for present purposes, that's not quite right. Clause 9 doesn't impose a prohibition on Lohomij, it imposes a prohibition on MRL not to dispose of any car without the prior written consent of the lender, assuming that such consent was not unreasonably withheld. But then still in paragraph 89, it's said, by the implied term contended for, MRL sought only for the court to recognise that Lohomij cannot circumvent this prohibition by seeking preemptively to sabotage a sale. And of course, that is a reformulation of the term which they've pleaded and for which they have previously contended. And the judge's rejection of MRL's argument in this regard is, with respect, difficult to improve upon. So I was simply going to take the court through that. We have the judge's judgment on this point in his judgment, beginning at page 328. Paragraph 309. The court sees there that first the judge cited the Marks and Spencer's case. At paragraph 309.2, he makes the correct point that MRL has not pleaded any matters that are said to justify the implication of the term contended for.
Can you enlighten me as to the relevance of that? Since when is that a requirement?
It's not of itself a requirement, but as Lord Neuberger held in the passage I just took the court to, when one is considering the implication of a term, one looks at commercial common sense, the background to the agreement, and facts known to the parties. So it could be a relevant consideration, but in the present case, there are no facts said to justify it, which would not if it were not otherwise justifiable.
But is it no more than saying in this case, in fact, it was envisaged that these cars could be sold subject to consent not being withheld. Therefore, one is in a factual matrix where one is looking at cars which may be sold, and therefore that is the extent of the factual background. And it would be said, no doubt, by Mr. Fenwick, that accordingly, it's that factual background fits neatly with a term, an implied term, which is that one shouldn't impede those sales in a way that then knocks on into the lack of necessity for consent or otherwise, because one has impeded the sales. So it's no more than that. That is the landscape in which we're looking at whether an implied term should be implied.
Yes.
No more, no less.
Precisely that, my lady. The point which I think is being made is there is nothing outside what is obvious on the face of the documents that someone says it's this other bit of background, this other bit of background fact that justifies the implication.
It's only the landscape of which we're aware.
Yes.
Isn't it the case that what's really being said here is that in any arrangement where a party holds security, which plainly can be released if they consent, and there may be an express term in that regard, but there should be implied into that arrangement a term that the mortgagee or holder of other security will not interfere in the process of seeking to redeem that security.
That is absolutely right. The consequence of that, of course, is that it's the difficulty with the elasticity of the phrase interfere, because the holder of security has a range of interests, and indeed, in this case, for example, they are permitted to withhold consent in their own commercial interests if they get to that stage. That is itself an interference with a prospective sale. If for their commercial interests they regard it as unattractive to approve the sale, that would be an interference.
Well, I wonder why this implied term is necessary simply as a matter of general principle, because if a holder of security acts so as to prevent the ordinary dealings of the debtor, permissible dealings in the ways being referred to, seems to be a host of potential causes of action, ranging from interfering with business or contract to fettering the equity of redemption. I don't know why you actually need an implied term.
Well, that's right too. Parties will often be in business together in a variety of relationships where one party would later object if the other party did something to harm them. And I deliberately put that in the widest terms. Parties in that business relationship, whatever it might be, will often complain, I can't believe you went and did that, I thought we were working together.
Well, what's happened here is the allegation is one of implied contract or common law, whereas in fact, probably you'd analyse this in terms of equity.
Well, because the powers of the secured lender have not been exercised, you don't get into the equity doesn't get it. We don't get involved in the obligations which are imposed on a secured lender when they exercise their powers. So we're not into that stage. What you look at is you say, is there anything in the contract expressly that prevents the parties doing this? It's not actually at this stage an equitable question. I entirely accept the point that there could be a tort in some circumstances, but you need all the necessary elements of the tort.
Does this not tie in with the question of good faith, as discussed in Jan saying? Because one conception of good faith is that you don't act so as to frustrate the performance of your contract. And why should one not apply a term into the amended facility agreement that Lohomij should not act so as to frustrate its performance? I appreciate that's not precisely what's pleaded. It might be said that the breaches alleged would not be breaches of such an implied term, but let's just start with the question of principle.
I accept, of course, that there could be a term of that sort. As my lord observes, that is not what has been pleaded. And frustrating the contract is quite different to what is alleged. When one talks about frustrating performance of a contract, preventing the other side from complying with their obligations, it's difficult to see how on the facts that are alleged, one would be anywhere near that sort of territory. The fact
Why?
that
Because if you can't sell the cars, you can't repay the debt.
well, that may or may not be right. That will obviously be a factual question. The relationship here is of a lender and a debtor and security. No doubt it is envisaged that the way in which the loan will be repaid is through the sale of cars, but not necessarily of this particular car, and it's certainly not of this particular sale. So one ends up in a slightly circular position of having to decide whether, by preventing this particular sale, if that is what happened, they actually frustrated the performance of the contract. But again, we risk finding ourselves in a very a position where it's very difficult to identify the exact term, and certainly difficult to say that what is alleged, even if it were accurate, would support that. We are obviously at this stage in an appeal. The judge has considered whether, if the term were as formulated, there would have been a breach of it, and has considered the implication of the term. I accept that obviously this court can reconsider the question of was the judge right or wrong on the implied term, but we'd be in difficulty if we end up with a different term, which the judge below didn't have an opportunity to consider. I should show the court also the express terms of the contract, because one of the judge's next objection, or next point, was that there are clauses of the contract with which the proposed term was inconsistent. And we can see this in the amended facility agreement, tab 17.
Just before we look at the clauses, where does he say inconsistent? He certainly says that having regard to the express terms, the implied term is unnecessary. But unless I've missed it, I can't see him saying it's inconsistent.
It's paragraph 4, line 5 of his reasons.
Oh, I see. Thank you. Yes, I was looking at subparagraph 3.
Yes.
Okay.
But so in paragraph 3, he refers to clauses 7, 8, and 9. If I can just show the court that, please. So this is in the supplementary bundle, tab 17, page 154. The borrower, clause 7, the borrower, the lender, and bonhams agree that as regards the sale of the remaining cars in the collection, A, the borrower is responsible for preparing a detailed marketing plan to be submitted for approval by the 31st of July 2015. B, the borrower shall every 30 days submit to each of the lender and bonhams a written report detailing the progress of the sale. C, borrower shall, as soon as reasonably practicable, after receiving an offer to purchase a car, notify both the lender and bonhams of the offer. D, if in the reasonable opinion of the lender, the borrower is not making sufficient progress in selling the cars to make it likely that all sums due to the lender will be paid in full by a termination date, at any time after the 31st of August 2015, the lender may, on giving 15 business days written notice, inform the borrower that it is appointed such persons as the persons as the lender and bonhams agree as the exclusive agent for the sale of one or more of the cars. On the expiry of the 15 business days notice period, the agents appointed shall take all such steps as the lender and bonhams may determine to be necessary or desirable to sell the cars for the best price reasonably obtainable.
Why is it not implicit in clause 7 that the lender will not prevent the borrower from selling the cars? Again, I appreciate that's not exactly the implied term pleaded, but let's just take prevent. Why is that not implicit?
Well, I think that question has to be asked in the context of clause 9. Clause 9, the borrower acknowledges that the cars comprise charged property and accordingly acknowledges, in accordance with clause 7.2a of the debenture, no disposition of any of the cars or any other car in the collection shall take place without the prior written consent of the lender, such consent not to be unreasonably withheld. So it's plain that Lohomij can prevent the sale of the car within the usual requirements of a such consent not to be unreasonably withheld.
So to this, that provided there's been no disposition, the lender can unreasonably prevent a proposed sale coming to fruition.
I don't think that is a submission that I made. The question is that we are looking at an implied term. And again, this is exactly the sort of hindsight approach, which with respect is not the right approach to an implied term. Because one can always end up saying, this bad thing is alleged to have happened. Surely there must be implied into the contract a term which prevents this bad thing from happening. But that is exactly the wrong approach with respect. The correct approach is to say, does the contract work without it? It plainly does. As my Lord Justice Phillips observed, there are remedies available if somebody maliciously interferes with someone else's business, for example. That, again, for example, is a good example of the dangers of implying this term. because if you have a deliberate harm to someone, then you can see why a tort might a tort claim might be brought. But it is certainly not obvious that an unintentional or non-deliberate interference with a prospective sale is something the parties would have contracted against. I can see, again, that you might say, well, there should be a clause that says, if the lender deliberately sets out to harm the borrower by preventing a sale, that is something which could be, which must be contracted, which there must be an implied contract again, an implied term against. But again, you then have to say, well, is that the right clause, because it's not the only available clause, and does the allegation stack up that it was deliberate?
We have something called the prevention principle.
I'm sure we do, my lord, but I may need to be.
Well, it's certainly a defence to a claim for breach of contract. The party who is claiming against you prevented you performing.
Yes.
And whether that is a principle of law or whether it is based on an implied term may be unsettled. But if there is such an implied term that you will not prevent performance, then why isn't that applied here? If there's obligations to sell these cars, why isn't there an implied term that other than pursuant to clause 9, its rights ultimately, well, in fact, what clause 9 doesn't say that Lohomij can interfere with the sale. It simply says that before you sell, you've got to get the consent.
Yes.
Why, apart from that, should you not imply a term which simply says you will not prevent the borrower from performing its obligation to sell the cars?
With respect, because it's not obvious and it's not necessary for the contract to work, and because although there will be some circumstances in which it might be said, the parties would have expected them not to do that. In other circumstances, it may not be obvious at all. So I can well understand why it would be a defence to a claim to say, you put me into this position of breach, you prevented me from performing. But that's quite different to an argument that says, you have a positive obligation not to prevent me, even unwittingly, from performing.
It's a negative obligation, isn't it?
I understand one can have. Well, yes. As I say, I can see why, as a defence, it makes sense to say you can't. It's almost an estoppel. You can't sue me for something that you've caused. It's just not right. It's not fair. That makes sense. But it's quite different to say you are contractually obliged not to prevent me performing, even if you do it unwittingly. I'm sorry, I'm just going to say that the fact that we are struggling with these different formulations of what the clause could have been shows in my submission that actually it's not a clause which is capable of clear expression. It's not obvious. And it's not necessary. The law has remedies for contracting parties who put the counterparty in breach. It has remedies for people who maliciously cause loss to others. And the general approach, for very good reason, is that the obligations between contracting parties are those set out on the face of the contract.
And I was just going to say, I take on board your submissions, but I was just going to say, isn't it obvious from 7D, and wouldn't the reasonable reader have assumed that one is also saying, in these circumstances, an exclusive agent can be appointed, that's 7D, and one adds, and the lender shall not otherwise, save in relation to clause 9, interfere with the sales?
Well, again, the parties could have formulated that, but they didn't. And it's not obvious that they would have done. Well, it's not so obvious that it's necessary to imply it. The obvious point, these are represented parties, they're sophisticated parties, they're negotiating their terms.
Having asked lots of questions, I should encourage you to complete your submissions in this regard.
I was very close to the end. I suspect I've covered the general points. I was really just going to go back to the judgment and take the court to the other reasons given by the judge, which we adopt. But I think in light of the debate that's been had, it's probably unnecessary for me to say more. I suppose I do draw attention, there are the points in 4. The first, that it's inconsistent with the express terms, I've dealt with that. Second is that interfering is impossibly vague. Again, I've dealt with that. And as I say, the same point would apply to preventing performance. You can understand why that acts as a defence, but it would be an impossibly vague term to have as a positive obligation. You shall not generically prevent performance of the contract, brackets, even unwittingly, would, I would submit, be impossibly vague. And then the third point, which is made by the judge, is a way of testing the alleged implied term. And of course, what Mr. Schlumpf had done on MRL's case at the meeting is to assert the rights of Lohomij as a secured lender. It is that conduct which is said to have breached the relevant term. And as the judge says, it's impossible, in my view, to see the justification for the implication of a term that would prevent a secured creditor at a meeting at which it was properly represented from stating its entitlements as such. And then paragraph 310 deals with the implication of the good faith term. And again, I'm not going to read this out. It's essentially the rationale is given shortly, but correctly, we say, and particularly draw attention to the case cited in sub 3 there, Morley and the Royal Bank of Scotland, which we have in the authorities bundle. It's at I wasn't going to turn it up, but it's at authorities 2 tab 16. That passage in the judgment of Lord Justice Males deals quite nicely with why one doesn't imply terms outside either equitable principles that the law has laid down over generations or the express terms of a contract between chargee and chargeor. My lady, that was all I was going to say. My known friend Mr. Gledhill has indicated he'd like to clarify a point as it relates to his client on ground 6. I'm told it'll be no more than 2 minutes, but unless I can assist further, that's all that I have to say.
Thank you very much. Mr. Gledhill?
My lady, I've been trying to avoid overlap on ground 6 and more or less succeeded, I hope. I've left the clause 9 amended facility agreement aspects to Mr. Colton, but obviously without knowing exactly what he would be saying. So I'll just clarify my position without arguing it, please. And the primary position is that the grounds of appeal don't contain an appeal in relation to the procuring breach of clause 9, which is the only way in which I would be implicated in this, would be for procuring. So primary position, grounds don't actually appeal the judge's decision on procuring. We've not read them that way. They don't mention in Romans 1 to 3 either bonhams, Mr. Knight, or procuring. If I'm wrong about that and this court reads the grounds differently as appealing on the procuring point, then my secondary position is that I adopt what Mr. Colton has said about the Clause 9 debate and the implied term and indeed the approach of the court in this area yesterday. And I rely on what the judge said to reject the procuring breach of contract case, particularly at judgment para 343 to 355. He gave numerous independent reasons for rejecting the procuring claim. None of them depended on findings of fact on disputed evidence, and indeed several of the points were that the procuring claim was unarguable on its face. Anyway, I just wanted to clarify and state my position without arguing it.
I'm grateful. Thank you, Mr. Gledhill. I think we're with you, Mr. Fenwick.
Thank you, lady. And I will endeavour to be complete by 20 minutes to 12. I'll address the grounds of appeal in order. So starting with the question of construction. There's been a great deal of emphasis on the letter before action and how the spring law letter in effect covers all the ground, including allegations of dishonesty and conspiracy. And of course it doesn't. As the court will have seen by reading it, when you look at it, although there are complaints made, there are no allegations of dishonesty. There could be none because there were no grounds for Mr. Walmsley writing the letter as a solicitor to put forward such an allegation. But the difference between the position at the time of the settlement and the time of the letter for action and the position in these proceedings is precisely the information provided by Mr. McLean, which I won't take you to. It's in the witness statements of Mr. Sullivan and Mr. Hilda, which I've shown you, and there the landscape completely changes. This is not a bit of slightly sharp practice, possibly. It is not negligence. It's not an estate agent out for themselves, auctioneer out for themselves, as sometimes are. This is a conspiracy, pure and simple, explained by one of the conspirators. And the learned judge said, and it was accepted by one of my learned friends, the learned judge took that conversation to have taken place and my client's belief in it as truth to be the case on which he must proceed. So when he was coming to his conclusions, he must have been doing so against the background that he accepted that Mr. McLean had revealed this conspiracy, hitherto unknown to my clients. And that is sharply different from the landscape at the time of the spring law letter and the content of the settlement. I then go on, because I'm going to take these points fairly shortly, to my friend's clear submission that it was obvious from the wording of the spring law letter that this was really a sort of veiled way of saying, we think you're being dishonest, we think you lot have done it all together. If that were the case, then in my submission, there is, as my Lord Justice Phillips at one point suggested the possibility, why not being taken as those solicitors, Jones Day, must be taken to have been aware of the principles, why not add the word, including claims in fraud or dishonesty? Four simple words, if it is really present to their mind, and you've been given a bit of evidence that it must have been present to their mind. There isn't any evidence of anybody to say it was present to their mind. Easy to do, and the fact they didn't is all the more striking if, as my learned friend submitted, they in fact believed those allegations were being threatened. With great respect, the suggestion that, oh, it wasn't necessary because of drafting techniques and mechanics, whatever they are. Following a precedent out of some book, why is there a drafting technique which in circumstances where you know you should cover all bases if you want to, where you're told that if you want to exclude fraud and dishonesty, you should say so explicitly, unless you can show in some other way, and therefore have the kind of debate we've been having, that there is an intention to include fraud and dishonesty. So the absence of it suggests not that the defendants were unaware of the possibility of a dishonesty claim, because ex hypothesi, they were the fraudsters, they were the conspirators. It is because there was not present, as between the parties, and cannot be suggested to be in my client's mind, any suggestion that this was intended to include a claim in fraud. Fraud is a thing apart. And I know my late friend Mr. Collins, on his customary steed, that conspiracy, the tort of conspiracy does not require dishonesty. I accept it does not require it, but like many other torts, negligence, breach, or breaches of contract, they don't require fraud or dishonesty. But where there is fraud or dishonesty which is pleaded and proved, that is a thing apart. And a claim which settles all claims in breaches of contract doesn't settle a claim for fraudulent breach of contract. Even if it could be said that the wording of the settlement was sufficient to settle a conspiracy which did not include an element of dishonesty. That's not the point here. This is a conspiracy expressly pleaded to be a dishonest combination to incur. And we say so in the very first part of our pleading. Now, I want to pick up one point. Learned friend, I think, again, Mr. Gledhill suggested that the without prejudice letter, which follows in the bundle, suggested, and I think I got his words right, suggested that Bonhams could direct Lohomij to do it. Now, that's not right. I'm not going to take it back to the letter because of time, but it's quite clear from the letter that we're saying what you've got to do, Bonhams, is you've got to pay off or settle with Lohomij so that they allow this to happen. We know you can tell them what to do, but you have, if necessary, to pay them the 13 million, to pay the interest. You've got to do whatever is necessary to do so. The fact that we think they might be able to, by paying them enough money, is not the same as suggesting that there is already some deal between them, which means that Bonhams can tell Lohomij what to do. Now, that's all I wanted to say on construction. Briefly, on sharp practice. The authorities are clear. The hypothesis on which one looks here to apply the sharp practice principle is that even if the court concludes that we were prepared to take the risk of settling all claims known and unknown, including claims in fraud and dishonesty, against my point one, or even as the judge said, we wanted to settle the claims even where we were a bit suspicious. We chose not to interfere further. The sharp practice rule applies really doubly here, because this is not a case where the defendants suspected that there may have been some dishonesty by one of their operatives at some stage, which they wanted to exclude, even if their operative had been fraudulent or dishonest, and that would be attributable to this is not even a case.
Sorry, I haven't understood what you're saying then, Mr. Bennett. Who's the defendant and who's the operative?
In this case, Bonhams and Bonhams and Lohomij and Lumen are settling the claims against my client, right? If they, at the time of settlement, don't merely suspect that there might be some unknown dishonest act, don't merely have a knowledge that one of their subordinates has acted dishonestly and that their knowledge may or may not be attributable to them. They know, for these purposes, that they themselves have deliberately and dishonestly conspired in order to injure my clients. And they don't say so. They know my clients don't have that knowledge, and they settle. And that is the sharp practice rule which says they should not be allowed to rely on a settlement, however wide, when they know something as serious as a conspiracy, and they know that the other side are unaware of it. And that's why it applies in this case. I want to move on now to the question of fiduciary duty. And it's important to remember that the fiduciary duty or duty of good faith on which we rely is in fact for a relatively short period. It's as pleaded and dealt with by the judge and dismissed by the judge, it relates to the effect of what we call the exclusivity agreement. And it relates to the period between the exclusivity agreement and when Bonhams actually agreed to become our agents, where there is no issue, but that as agents they owed us fiduciary duties. Now, we know that the commercial agreement by which they undertook that duty of agency, together with the duty when selling the cars, to do so as fiduciaries and in good faith. That duty was backdated by the commercial agreement of 30th of June to the 29th of May. It's supplementary bundle, page 80, clause 1.1 of the commercial agreement. So we're talking about, it says, parties agree this agreement to be deemed to have and given effect retrospectively as of 29th of May. The avoidance of doubt, MRL and Lohomij confirmed this agreement is the agreement regarding Maranello collection referred to in the agreement. So fiduciary duty is owed with effect from that date. So I'm dealing with a period before then. Can we look at the way I think that you've seen it before, but I just want to pick it up in our pleading. It's in Core Bundle 2, page 376, paragraph 28. By insisting on exclusivity, Bonhams specifically required MRL stop negotiating with RM in practice committee. In the circumstances, Bonhams owed a fiduciary duty to act in the best interest of MRL as their agents for the transaction, and or to obtain the best price for the collection, and alternatively a duty of good faith. So much of the argument with respect appears to take Lord Millett's famous Mothew, word in Mothew, when it was Lord Justice Millett, the wrong way round, and say, if they're a fiduciary, then they owe all the duties of a fiduciary. They're fiduciaries because they owe fiduciary duty. We have pleaded the fiduciary duties they owed, which is to act in the best interest of MRL as their agents and to get the best price. it is not a duty as such to defer their interests to those of MRL. And this is not the situation where we have two parties negotiating whether or not to enter into a deal. It's common ground between them that unless something goes wrong, bonds will be acting as agents, will be selling the cars, and as agents will owe those duties. The negotiations are about the precise terms on which the agreement will take place. Who's funding it, who's buying it, and so on. Those may be things where they have a different interest, but there cannot really be said that there is a difference in their interest as to whether you're looking at the best interest of your principal as agent, or you want to get the best price for the collection. Those are duties which can be owed perfectly well. Now, when approaching the exclusivity agreement, the learned judge held, and it's understandable, that it may not be much more than an agreement to agree, but it is an exchange under which both sides accepted obligations. My client accepted the obligation to drop the dealings with RM, give them exclusivity, and they, in exchange for exclusivity, we say, undertook a duty to act as our agents in good faith to get the best price. Now, it said, well, that really wasn't an agreement. You could have just breached it. But put the boot on the other foot. Just assume that Bonhams had been acting in good faith. Assume that they had gone and they had arranged to book a venue and paid a deposit at Earl's Court or Goodwood or whatever for the cars. They had spent money on marketing, advertising, whatever it is, in anticipation of the agreement. And then MRL turned around and said, well, actually, we said we'd stop negotiating with RM, but we didn't, and they're now going to pay us a bit more. You can anticipate that Bonhams would, in those circumstances, have said, well, you agreed with us that you would stop, and we've altered our position in reliance on it. In just the same way, my clients altered their position in reliance on what was being said. And we say that is sufficient for it to be arguable, that's all I have to show at this stage, arguable that they owed duties of a fiduciary character or duties of good faith arising out of it. And I want to just take the examples which floated across the court, between the court and the learned friends, just for a second. I think it was my Lord Justice Arnold who refers to a purchaser asking the vendor to take the property off the market whilst he considers selling it. And does he have some duty arising out of that? But of course the answer to that is no. On the other hand, assume that the agent B, Stratton Parker, to name without wishing to be rude about them, Stratton Parker come along and say, you've got this house on with Knight Frank. We can get you a much better deal for it. Take it off the market. And I know you've got an offer, but turn the offer down and we will act for you. And in fact, what we will do is there is a great exhibition coming off next week, and we will advertise it at that exhibition, and you'll have a jolly good sale. In fact, they don't do anything, but he takes it off the market. And in fact, the agent had some reason of their own for not wanting the sale to go through, not wanting the first agent to have it. Can it be said, once they become agents, they will undoubtedly owe duties as agents, as fiduciaries. In the intervening period, can it be said that it's unarguable that they owe no duties? And we say not. Take a solicitor, and I'm not going to take you there, but in KIA, tab 9, there's a reference of paragraph 133 to Langstaff, which was the case where a solicitor in negotiations owed a duty because he'd previously been a solicitor with a duty of good faith. Assume a solicitor acting on, is asked to act for a client. He says to the client, yes, I will act for you. Yes, I will issue proceedings with you. Sack your current solicitor. But of course we have to go through, nowadays, AML, proof of identity, all the rest of it. That's going to take several weeks. The solicitor then sees that there is a limitation period which is expiring, does nothing about it, doesn't tell his client, goes off on holiday, and then says, well, actually, I can't act for you. It is said that no duties are owed by that person who has agreed to undertake the obligation simply because the contract hasn't yet been entered into. Those are a few examples of why, in my submission, it is at least arguable that in circumstances where my client is asked to do something that is detriment, in reliance on what is being said to be a future agency, gives rise to duties of good faith before the agency contract is actually signed. And that's as far as I have to go for that. Now, if I don't, and I don't succeed on that, and we then come to the question of the conspiracy, true it is that I cannot rely on the alleged fiduciary duties and duties of good faith in the period from the exclusivity agreement, so-called, and the date on which they became agents, 29th of May. But I can and do, as a pleaded, and would be entitled, if I win on ground 1 or 2, to plead their breach of fiduciary duty as agents. And that's included in our pleading. So if we win on ground 1A or 1B, but fail on ground 2, some of the claims are barred, but the claims of breach of fiduciary duty after the agency began and the claims in relation to the conduct of the sale remain. I want to move on now to, I think, issue 5.
I'll just ask you one thing in relation to the fiduciary duty argument. I understand that eventually Bonhams did become the agent and then conducted the sale of the cars. But in your case, the arrangement from the exclusivity agreement that you allege was proceeding was that Bonhams would in fact purchase the cars. So where does the agency and fiduciary duty arise in that arrangement?
I clearly didn't explain it properly, not entirely my fault. This was not, if, as you recollect, an out-and-out purchase. It's not, we'll sell you the cars for 80 million and off we go and go and spend it at Monte Carlo or buy another 10 Ferraris and try again. What it was is, we will take the cars, you will buy them, so property will pass, but you will sell the cars at best price. And what will happen is, you will get the first 80 million, you will get 4% interest on them. The balance of any sales comes to us, and any cars which are still unsold come back to us. So duties are owed in respect of the conduct of that agreement because they are both purchasers and agents owing duties under the sale to procure the best price.
Why is there any need for fiduciary duties there when it's dealt with by contract? Both parties plainly have an interest in maximising the revenue.
Yeah.
There's no need to say that Bonhams were under fiduciary duty in that regard. They had contractual duties, and they were both, and their interests coincided.
Well, that's very well in the good world, where people actually do what they say they will do. But if we are right, and Mr. McLean is right, or was right, there was a conspiracy, and what they actually wanted to do was not sell them the best price. But
we're looking at what duties arise from the exclusivity agreement, and you say that agreement, which you say was for Bonhams to purchase the cars from you, and then to sell them pursuant to an agreement yet to be structured, gives rise as a matter of law to a fiduciary duty.
Alternatively, to a duty of good faith.
Yeah, and it doesn't seem to me that's quite so straightforward.
No, I can see that, but it's certainly not in my submission unarticulable in the circumstances. We will still have a competing argument at trial where they will still be saying that they were never going to buy it, and in the event they didn't buy it. Now, we have this conflict, and it's when we come to look at issue 6, one of the matters on which we rely as showing the judge conducted a mini-trial was what he dealt with about Mr. Walmsley. Let's just pick that up now, because it's Core Bundle 1, page 205, paragraph 44. You've seen it before. Emerald's case was only up on the 27th of May that they said they wanted it to be a loan. Ms. Sullivan said, I immediately refuted the suggestion, referring to the fact that the deal had been agreed in the letter Mr. Walmsley and Mr. Brooks. This won't do. We have here a conflict of interest. Emerald's case, the circumstance which a loan was first mooted, makes no sense on its own terms. It is incredible in the light of the document. Now, well, the document he's relying on is the document in which, on the 22nd of May, Mr. McLean said that a member of the Lumen Group will advance the funds. But what the learned judge did not take in, and I hope I make clear in my own submissions on this appeal, is that there was always going to have to be somebody advancing the funds in the first place, because otherwise the sale couldn't take place. So the mechanics inevitably involve an advance in order to buy, followed by something else. We say a sale, they deny the sale. Mr. Walmsley said in the email which you looked at of the 25th of May, he says, when we were met on Friday, Sunday night, Friday the 23rd, day after, when we met on Friday, we were discussing a sale. And the judge rejects all that and says it's impossible. So what we say is that whether they were acting all the way through as agents without owning them, or whether they were acting as agents for both of us, with them being the legal owners, does not affect the existence of the same duties to take care. And you don't, you could put it as an implied term in the contract of the agreement which never happened. It might have been expressed. Bonhams will use its best endeavours to get the best price. But if it's not expressed, then they will still owe duties of a fiduciary character when they're acting for both of them. That's, I think, as far as I can take it. I'm looking at the time. There's a very short point to make in relation to limitation. And to do that, we have to look at the defence of Bonhams and Butterfield, and it's in Core Bundle Volume 2, tab 17, page 518.
518.
518, I think, yes. Summary of defence, 5.4. The auction took place in accordance with proposals expressly agreed by MRL. It was conducted by B&B pursuant to an agreement under which the claims against B&B are now time barred. Now, the learned judge purported to say they were time barred. If we are right on issues 1A or 1B, then there is a conspiracy claim which we can bring, which is not time barred because of the discovery principle and the fraud principle. I accept that the freestanding claim would have been barred if it hadn't been settled anyway. But I think there's nothing between us on that. So I'm going to go now to what I call part 2. And I think it's going to take me 5 minutes. I hope the court will indulge me while I do it, because I'd like to do it properly. First of all, I'm going to take the implied term and get it out of the way. The reason we included provision for an implied term in paragraph 28 of sorry, that's the wrong reference. Paragraph 67A of the proposed amendment, page 386, was because all the answers to our complaints about Mr. Lumen and Lohomij's conduct in relation to sale 1 were met by the answer, well, you never put forward a sale, therefore clause 9 doesn't bite, and therefore we can do what we like. And that's why it's in. It's put in that they would not prevent and or interfere with. Learned friend Mr. Colton said, well, of course, interfere with could mean doing something accidentally or involuntarily. It's absolutely plain from this pleading of conspiracy and deliberate intent to injure that we're talking about wrongful conscious interference and prevention as opposed to accidental one. And in that context, it is precisely the kind of term which you might say you don't need to plead because it's obvious, but where it is said there is no duty because there is no sale, we should be allowed to allege that there was a duty not wrongfully to prevent or interfere with, alternatively an implied duty of good faith, bringing in the equitable obligations which arise under it. And learned friends' suggestion, well, so long as we don't actually get to the stage where we're asked and we refuse unreasonably, there's no reason why we can't do it. Take the task example, which the judge found didn't exist. We're negotiating with a buyer, they insist on attending, and they say, and I'm paraphrasing, it's not the exact words as pleaded, they say, well, we're entitled to foreclose at the end of the month, and when we will, we'll be looking to get back our loan. So you might want to deal with us. Now, that is not a breach of clause 9 because we haven't got there yet. Is that something which there is no obligation not to do? In my submission, plainly not. And we've tried our best to put in words the reason why that conduct is a breach of the agreement or a breach of the implied duty of good faith. I want to pick up 3 examples only. And what we say overarchingly, I absolutely accept. I have not gone through every bit of this section to show where the judge got it wrong. We did try. I've got about 25 pages of examples where he sort of says things, says that doesn't look likely, looks at the few documents which exist, no disclosure, and says, well, on those documents it doesn't work. Our overarching point is that the judge was lured into embarking on an exercise which he never should have done. And having embarked on it and started to look at documents and make decisions and conclusions, both of law and fact, based on a limited set of documents, he was doing the sort of thing which could be done by the trial judge without the material available to the trial judge. This was not a focus. That particular cause of action cannot work because, self-evidently, everything required an evaluation of what he had. And for us to have had to produce all the documents, they would have had to produce all the documents, and we'd have had to have evidence before it could properly be tried. So that's our overarching ground by the entirety of phase 2 should not have been dealt with by the judge. He should not have dismissed any part of it, and should have allowed us to continue. And there are 3 examples that I need to pick up. I picked up Walmsley already, so I don't need to go there. In my skeleton argument at paragraph 76,
Walmsley is phase 1, isn't it? Not phase 2.
it is phase 1, but it's an example of the conduct of the phase 2. And
I don't understand you to be making the mini-trial complaint in relation to it.
No, I'm not. But it was one of the examples of findings it was open to judge to make to show how careful he was.
But if there are so many in phase 2, why do you need to focus on one in phase 1?
That was because my learned friend mentioned it. It was one of the 3
No, I
examples.
think you mentioned it in your submissions.
I mentioned it in my submissions because it was necessary as part of my submissions as to why the fiduciary duties arose. And because there was clearly a contest of evidence and it wasn't as plain as the judge said. I'm going to focus on 2 examples of phase 2. Paragraph 76 of my skeleton, page 56 of Core Bundle 1. This is the point where the judge comments on Ms. Wolf's evidence about Lohomij and Mr. Luhmann's involvement with the choice of venue.
I'm sorry, sir, could you give me the reference again?
Yes, of course, I'm so sorry. Core Bundle 1, page 56, paragraph 76. This is where the judge says he sees no evidential basis for gainsaying the statement in Ms. Wolf's witness statement that Lohomij and Luhmann had no involvement with the choice of venue. In our pleading on page 378, tab 13, paragraph 38, we say at a meeting on the 3rd of June, this is where change of venue was raised and decided on. Mr. Brooks and Mr. McLean, acting on behalf of both Bonhams and Lohomij, informed Mr. Sullivan if MRL did not agree to the auction in California, then Lohomij would simply wait for it to default on the facility agreement, at which point the collection would be repossessed under the terms of debenture. In Mr. Sullivan's first witness statement, supplemental bundle, page 195, it starts at page 57, paragraph 57, we're talking about 56, I was so angry, heated discussion, and we go over the page, 60, in the end, Mr. Brooks and Mr. McLean told us Mr. Luhmann had said if we did not agree to the new terms, Lohomij would foreclose. Now, learned friend said, my point in paragraph 76 is wholly unsupported by the evidence. And I've just shown you a pleading and evidence which supports it. And the judge, despite that statement, says there is nothing to gainsay Miss Wolf's statement for the purposes of the strikeout that Lohomij and Luhmann had no involvement in the change of venue.
This is also phase 1.
I'm sorry?
This is also phase 1.
No, it's phase 2.
I must have misunderstood.
It's phase 1. It is, all right, it's phase 1. But,
You have 3 examples.
yes.
And the first 2 are both phase 1.
So I'm going back to 306, which of course is the one which we've already looked at. And 306, I made my submissions about, if we look at, this is where the judge said that it was wholly inconsistent. If we were to look at paragraphs 123 and 125 of Mr. Sullivan's first witness statement, and they are at page 207 for bundle 2. He says, 4 or 5 meetings with Mr. Rickett and I, before they pulled out, FRG pulled out of cell 1. First one was on the 2nd of June, attended by Mr. Schlumpf, Rickett, Schmidt and Hilda, Plain and me. One point Mr. Schlumpf asked I want to leave the room, and then we get the aggressive telephone call. Clear to me that Rickett and Schmidt, standing outside, we overheard it. 125, another meeting, which I believe took place on the 6th of July. I recall witnessing Mr. Schlumpf and Mr. McLean telling Mr. Rickett and Mr. Schmidt in my presence that MRL owed 38 million to Lohomij under a loan agreement. Lohomij now required immediate repayment. That is consistent with our reply, which is in tab core bundle 2 at tab 18. That page, read my own note. Paragraph.
Is it 54?
I'm sorry?
Is it page 666?
It's in the I'm sorry, I've got the wrong reference. That's because I misheard what my lady said. 666.
Yes.
Yes. Thank you. That says 4 or 5 meetings. First meeting on the 2nd of June. Material events of those ones set out in point particulars of claim. Further meeting on the 6th of July, where we get the what Mr. Sullivan says. Now, the learned judge said, I accept Mr. Schlumpf didn't attend a meeting. Well, that is simply for prejudging the evidence. And it's an example of why, in my submission, the court should conclude that the exercise carried out by the judge, when you read it again, is an exercise which he should not have carried out in the first place. I have overshot, for which I apologise, but those are the end of my submissions.
Thank you very much. Lord Justice Arnold?
No questions, thank you.
Thank you very much indeed, Mr. Fenwick. And thank you to everyone for their submissions in this difficult and complex case. And thank you for everyone behind who hasn't made submissions, although one of you might have been called upon. And those also who are part of the teams who have prepared all these documents for us. Thank you very much indeed. As you'll appreciate, we will reserve our judgments and they will be dealt with in the usual way. And that is that you will receive a draft which is for typographical errors to be pointed out only, no re-argument, thank you. And also, I must remind you about the embargo in relation to those drafts. As you'll appreciate, there have been some very unfortunate occurrences lately, and I would not like any contempt proceedings to come out of this hearing, put it that way. And as usual, therefore, we hope that you will be able to deal with any subsequent matters of the order by agreement between you all. And if you can't do that, that you will put in short written submissions, and that we will deal with that on paper. And as you'll appreciate also, these days more often than not, judgments are handed down online. But in any event, your attendance, one way or another, will not be required. So thank you very much indeed to you all, especially on these difficult days when you've all managed to be here for a further continuation of the hearing this morning. But we most definitely could not have fitted it in yesterday evening. Thank you very much indeed.